Good morning, everybody, and welcome to our Kelly Dry webinar today, Pricing 101. I'm going to give it just a minute and let folks join into the meeting room here, and then we will get started. So stand by. All right, it looks like we've got a critical mass now of participants, so we can get started. Well, good morning again, everyone. I am Paul Singer, partner here at Kelly Dry. I'm joined by my colleague, Alysa Hutnik, and we are excited to present today Pricing 101, Key Considerations Across Privacy and Consumer Protection. This is the first webinar in a three-part series that Alysa and I have put together that really focuses in on both legislation and enforcement that is happening in the pricing space. This has become an extremely hot topic right now, and there are a lot of key considerations for businesses as they think about pricing in this ever-changing landscape. Today's presentation, although we've dubbed it a 101 in key considerations, as Alysa and I talked about it, we really thought the best way to approach this is to provide our thoughts on what a top 10 list is for all of your consideration as to the primary areas that you need to be concerned about right now as we've been tracking what's been happening in an enforcement community. Before we get started here, I do want to give just a little bit of housekeeping, and then we'll give a little background before we jump into our top 10. So first, if you have questions, please use the chat feature that you'll find in the Zoom. We will be monitoring the chat for questions. We will do our best to try to get to them throughout the course of today's presentation. But in the event that we don't, we will obviously follow up with you directly, but we also will be putting out a blog post about this webinar, and we can try to address any questions in that as well. But we'll have our contact information available for everyone if you want to discuss after the fact. Also, this is a presentation that's eligible for CLE. So if you are seeking CLE today, at some point during this presentation, we will read out a 4-digit CLE code. We will read it twice and only twice. So please make note of it when you hear it. And then after today's presentation, you'll be provided a link where you can provide some contact information, and then you'll be asked to provide that code to verify that you attended. So with that, I'm going to jump us into our presentation today. But before we get to the top 10, there's just a few things we wanted to flag. Today's discussion, I think, is largely going to focus on consumer protection related concerns and privacy related concerns as they really affect pricing decisions. But I will just flag in particular that there is an increasing push of an antitrust attention to companies' behavior and how it can impact pricing. And we're seeing that especially at the state level, where we're seeing both Republican and Democratic AGs form coalitions to look at various practices and how they can potentially impact pricing. For example, just last week, Democratic AGs held a press conference where they were discussing their need to step up their enforcement of state antitrust laws, given the lack of enforcement on the federal side. And really, again, a lot of that need stems from ensuring that there is not improper collusion or other practices that could impact consumer pricing. And then on the Republican side, we've seen a series of efforts focused in particular at various ESG initiatives that could potentially impact consumer pricing based on agreements to only engage or utilize certain products. And we're seeing this in a variety of different sectors. Most notably, we've seen it stem in sort of investment firms and other financial areas, but more recently just in terms of consumer products and the components of those products. And so I just put that flag out there because it is an important consideration. Related to that as well is this year's National Association of Attorneys General presidential initiative, where AG Tong in Connecticut has created a year-long focus on driving down costs for American families that is already hitting on a lot of the topics that we're going to talk about today. So this is definitely an area that is in the news front and center. And a lot of that is because this is a significant election year, and the cost of goods and services is definitely a major focus for consumers, and is going to shape how the election plays out. So with that, let me pass it off to Alysa to do a quick intro, and then she can jump into our top 10.
Thank you, Paul. I'm Alysa Hutnik. I chair our privacy practice group. And just some of the thought process as Paul and I were thinking about this topic. One, many of those in the call, you're responsible for either product counseling, compliance counseling, privacy, advertising counseling, and there are a lot of issues that require your attention. And I think our thought was with this topic at this moment in time, that this concept has just really rose just staggeringly right at the top from an attention issue. And it's an attention issue on a variety of privacy topics, which we'll get into, but price has always been a material factor when it comes to evaluating an advertising claim. But almost the zeitgeist of the moment of things being expensive, there's certainly so much of the recent polling that American sentiment is very concerned about the economy and price and feeling squeezed. And so all of that really directs regulators and state legislatures with attention to, well, what are we doing on this topic? And so that's where you just tend to see more muscle and attention on, well, how can we go after this? And for some of these topics, these are issues that have been around for a very, very long time, but they take on an added relevance at this moment in time. So I think part of, again, the emphasis on this topic and the series that we're doing is really thinking, and maybe with fresh eyes, around some of the advertising claims and the data practices, and thinking, what is our affirmative story? How are we handling these issues? And as we walk through the different topics, definitely feel free to post questions, but given how there's such interest on these issues, taking some pretty, fresh eyes on, do you have any low-hanging fruit? Are there areas here where it could benefit just with some extra eyes, extra attention? So with that, I'm going to turn to our first number one issue, which is surveillance pricing. It's such a hot, loaded term. We are hearing it a lot. We are hearing it at the state legislature level with, gosh, nearly, I think, over half of the states with different versions of introduced legislation. What is it? One, we've got the concept here. The thought is that if you're using a consumer's personal data, whether it's browsing, whether it's individual data attributes, to set a specific customized price for the product or the service that the person is looking to purchase. There are a lot of raised concerns over I will say adjacent topics. So whether and how physical stores, walking into a store, and whether you're going to see some individual prices. We will talk about electronic shelf labels, which I think can be sometimes a misnomer when we're talking about surveillance pricing, but why there is some, why those topics come up quite a bit together. And you'll hear other terms: dynamic pricing, surge pricing, personalized pricing. I think it's really important to look at terminology. Surveillance really sticks. It is a clickable term. And if we think back to, interest-based advertising, relevant advertising, obviously very familiar terms in the privacy space, there was some rebranding around that in the teens. I think it was like mid 2015, 2016, where we started seeing surveillance advertising being a concept. And that certainly got amped up during the last FTC administration, where how is personal information used to power ads? And there was a lot of scrutiny. That's a very supports the internet, pretty common. But we saw the idea of, it looks like, Paul, we lost our slides, but the idea of surveillance pricing, the price point getting added to that. And if we look to what the FTC has done, In the last administration, they did what's called a 6B study, where it's an educational study, and they asked intermediaries. And I think that's really important. There was not an investigation of particular companies, but it was an educational study asking and really looking at where some of these intermediaries, are they in fact doing surveillance pricing? And the report came out in 2025. And there was a whole lot of hypotheticals in that report. And I think that's important because as we hear about surveillance pricing, there's almost a race to a presumption that it's already happening quite a bit. And I think one of the issues is whether it is in fact happening, and a lot of confusion over whether a product price is informed and powered specific to a person by personal information versus if we are doing interest-based advertising and somebody may see relevant offers that uses personal information. And there is a lot of that just gets smushed together. And so I think it's important to pull those apart to think as we issue spot. And I'll get into that as we go through this. But I think the background is really important because the term gets raised a whole lot without actually unpacking what we're talking about. So with that, I think, Paul, if we go to we're probably ready to slide. Perfect. So Paul, you mentioned the UDAP issues, and certainly we've seen kind of with AI being such also a key kind of component here, worries about at the state level, but also at the federal level in terms of DOJ, are companies colluding around pricing with algorithmic decisions? Is data being shared in a way that might power prices? So that's on the one hand, we definitely see that concern, and some of the state bills that we are seeing sometimes do merge those two topics together. So I flag that because I think it's important to unpeel that as we think about it. And then we had New York, which enacted their law, and it requires an affirmative disclosure around when you are doing what they call algorithmic dynamic pricing. They don't have a whole lot of exceptions in that law. And so I think for many companies, if you have loyalty programs, if you have discounts that are informed, coupons, relevant offers that may be informed by your browsing or other history with the company, whether that's triggered, and then you have to do that disclosure. And I compare that with Maryland, which is a new law on surveillance pricing, where they are very specific and excluding loyalty programs. And I think that's also a key, kind of how states are really wrestling with how to define it, what they're concerned about. Is it just prices increasing? Or is it using personal information, including in ways that might decrease prices? And those are really important topics to dig into as you're looking at any particular legislation. And then the other big development, of course, was from the House Energy and Commerce Committee with Ranking Member Pallone sending inquiry letters out to a very long list of companies with very long, detailed set of questions, asking if and how they may be engaging in surveillance pricing. So I think one, it's just another example of this topic is not going to go away and continuing to be covered by news. But I think really is the critical eye on one, is any company actually doing this? One, and if they are doing, using information, of course, to offer personalized advertising, is that somehow roped into this in some concepts? And so something very much to continue to keep an eye on.
Yeah, and I just want to chime in with this, and apologies because I don't know what has happened to my background or what is going on with Zoom, but I, the AGs actually just discussed some of these points at a recent meeting a few weeks ago, and I actually took maybe not some relief, but took notice of the fact that they were really trying to dig into the distinction that you raised at the outset, Alysa, about the difference between what we're calling surveillance pricing, which I really think is, to your point, this focus on using your personal information in a way that affects the price that you see, versus concepts of dynamic pricing, surge pricing, things that have existed for a long time and that I think the enforcement community generally recognizes is an acceptable business practice, right? Because, and the key difference there is that there are factors external to your personal information that are setting those differing prices and that are making those prices fluctuate, as opposed to the kind of horror stories that you're hearing that I think are largely hypothetical at this point, where it's, I walk into a store or I visit a website and you and I are both doing it at the exact same time, and some personal trait about me is causing me to get a different price than another person. That's where I think we're going to see so much focus and so much attention. The concern right now is that you're seeing so much of this legislation that's coming out that I think is trying to preemptively address something without any of us really sort of stopping to dig into what practices are really happening today and what can happen, right? What does the technology actually allow us to do, and what are we capable of doing? So, I will say that I think enforcers are starting to take notice of that and try to think through this, what their approach should be. And I think that's something that the business community really needs to be engaging now at both a enforcer and legislature level to be able to communicate exactly what is happening in the space and why prices vary, and some of the positive benefits that consumers can receive from some of these practices.
I'll just add that looks like some folks had put some things in the chat. If you do have questions, I think for now, definitely use that Q&A. And again, we're going to keep trying to get to it. But one of the questions right now is using personal information to lower the prices for certain consumers. Is it covered by any of these laws? That is exactly the issue. I mean, that is one, I think I would separate between whether it's the base price of the product, that you're seeing a different price for how the product is actually priced. There's concern around that. And then versus, is somebody getting a particular discount offer, a coupon that is using personal information that would lower the price for that person? And that latter part is something that is fairly common. And I think what we've seen in terms of the state legislation is they don't really have, they've not put that on the it's okay list just yet. The laws are written really broad. They're not narrow to whether a price is just being reduced. California Department of Justice, the AG's office there, has an enforcement sweep on this issue. And they're also not super clear in terms of where they net out on this. But if I take this from an unfair and deceptive trade practices mindset, the idea and the concern would be if people are getting left out, right? A lot of people lost jobs. Maybe they weren't as sensitive to pricing a year ago, but they now are. Are they excluded from the ability to be offered promotions and discounts because they're put in a not interested category from really old behavior? Those are some of the things that I think certainly the state legislatures and the regulators are trying to figure out.
Okay, so I think this can take us to the next slide, where we're now going to move on to number 2, which does kind of interrelate in some ways, as we're going to get to in a second, and this is pricing accuracy. I will say that on the state AG side, this has been an area of attention for a number of years now. And when we talk about pricing accuracy, we mean very simply, is the price that you see going to be the price that you pay? And this largely comes up in the brick and mortar scenario, where you walk up and pick an item off the shelf, you see a price on a shelf tag, and then when you go to ring it up at the register, a different price rings up. Every state has state laws very specific to pricing accuracy. There are, in many states, separate agencies that do inspections and, try to verify that the price you pay is the price you see on the shelf. So there are historic mechanisms in place to look at this, but pricing accuracy, I think, is just an area where electronic shelf labels have become incredibly important, right? So you've seen a number of retailers pivoting to use electronic shelf labels as the solution to pricing accuracy, because with an electronic shelf label, because it's tied into the point of sale system, you can ensure that when a consumer goes and sees the price that's on the shelf, it is matching up to the price that's in the point of sale system. And so those kind of real-time updates, it avoids the need for an employee to go and physically change a shelf tag, which, if they miss one or they get behind on their work, is what generally can cause that kind of mismatch and raise some of these pricing accuracy concerns. There is no doubt that electronic shelf labels can help with pricing accuracy because it is tied together like that. But obviously, electronic shelf labels also carry with it some of the potential, or some of the allegations that they could potentially be used to manipulate pricing in a way that also then could be dubbed surveillance pricing, right? Where somebody in a physical store could see a price change or a price change just for them as opposed to somebody else that walks up to the shelf. Again, there's no evidence that that's happening today, but it's the fact that there is new technology being rolled out that I think has raised some of those concerns. And so you've seen a number of states, as Alysa mentioned, as they're considering legislation on surveillance pricing, try to address this by either putting a moratorium or a ban on the use of electronic shelf labels. But that kind of approach then conflicts with the need to create this dynamic to improve pricing accuracy. And so I do think this is another area to continue to watch, because I think how pricing accuracy interplays with some of these approaches that legislatures are considering in addressing surveillance pricing is another area where I think especially the business community can have a voice and can make sure that people understand this. So I flagged this at the outset, but we have seen states very active in this. There is one particular retailer that has had, in the last 5 years, has had 5 different AG actions and a class action, all on these pricing accuracy issues because of repeated failures of inspections and repeated complaints of consumers experiencing higher prices when they get to the register. We've seen a number of local governments looking at this, especially in California, where they have very active DAs. They're also engaged in going out and checking for pricing accuracy. So I will just say this will continue to be an area of priority for the enforcer side, but it's just really important to make sure that legislatures also understand this dynamic and how ESLs interplay with pricing accuracy.
And Paul, I'll just add, a practice note. We see a lot of interesting vendors with technology trying to help retail stores with understanding full funnel, understanding advertising and measurement, and when there's conversion at point of sale, right? Trying to really merge data from online to brick and mortar to help inform brands, right? What is working? And so there's some very legitimate business purposes for why some of those insights and tools may be important, but it does feed into kind of at a very granular level, what personal information is collected, when, where, how it's being used, and what's the different technology. And I think it hasn't helped a lot of the companies, particularly in the vendor space, referring to everything as anonymous. It's all anonymous, de-identified data. And we are talking about pseudonymous data. There is ID to ID matching to help with measurement, to help with a lot of those things. And I think some of the credibility gets lost when we're not being upfront about the landscape has changed in terms of what's personal information. There are privacy concerns, but then kind of we skip to we're concerned about this to all these bad things are happening, and therefore you're right, what is the theoretical thing that could happen with things like electronic shelf labels when we're not actually seeing that in practice? And so I think it is a reminder to be upfront, to be knowledgeable about the data practices, about the technology practices, and more importantly, what are the safeguards? If you're using certain technology, what are the safeguards that we are putting in place to really anticipate, foresee the kind of concerns that are being raised with this legislation, so there's not an overreaction?
Yeah, I think that's exactly right. And I think, look, I mean, to just emphasize the point, in my mind, right, the approach should be a conversation about what guardrails can be put in place to ensure that this doesn't going to start to encroach in the kinds of concerns that people are flagging, right? But that is a conversation that needs to happen.
All right. So then, Paul, where are we? What's the next hot topic?
So I think this takes us to
we're gonna get to number 3, right?
Number 3. Yeah.
3. This one I feel like could be 3, 4, and 5, but we are keeping it just to 3. It's subscriptions, which has been one of the most enforced areas at the federal or the state level. The FTC alone, I think, has brought nearly a dozen enforcement actions tens of millions, hundreds of millions, not even counting the Amazon case, which, obviously was a huge, huge number. And these are a focus. They're a focus of the states. We've got a ton of auto renewal laws that are in place, which have very distinct requirements. They're not all the same. You can't just say, here's the one I'm going to follow as the standard for the US, because there's definitely nuances about it. But ultimately, auto renewals are about where you're making an offer where the consumer, if they don't do anything such as canceling, does that mean it's their continued consent to be able to charge them? So certainly think of streaming and any type of ongoing service, loyalty, where you may have a premium loyalty program where somebody is paying for the benefit of that. That is an ongoing basis. Sometimes these are month to month, sometimes they're a year. There's all different time, cadences to these, but they are heavily regulated. And they are very much scrutiny. And I always zoom out and think, well, why is this such an issue now? And if you consider how almost everything is a subscription, or there's a subscription offer. And I think about kind of the debundling with cable, and certainly we had all the a la carte options, which were subscriptions. That's one thing we've seen economically, how there has been really positive feedback for companies who offer subscriptions because of the predictable nature of revenue on there. We've seen kind of with the rise of privacy laws and concern around a loss of signal, where you aren't able to capture as much information about your customers, and subscriptions really being a way to do that. So I think that's important to see why there are legitimate business use cases on having subscriptions, but in the rise of subscriptions and consumer behavior, which even if you say everything the right way, sometimes consumers forget to cancel, and then they have charges that they look at their invoices maybe 9 months later and do not like that they were paying a whole lot of money for a subscription that they agreed to, but they forgot to cancel. And anytime you have lots of consumer complaints at large, you are going to get regulators' attention. And I think that that is exactly what we have going on here. So I think if we go to the next slide, we've got a hot off the press example from a recent FTC case. And this was, I think it's really helpful to not talk in the abstract, but really look at some of the examples. So this is one of the FTC's most recent cases, but the FTC has a lot of other cases. And in those complaints, you can see visuals. And I think those visuals are helpful to share with the business on what wasn't enough, right? What wasn't clear and conspicuous. And anytime you have a fee, such as what is the cancellation fee, and really thinking about the amount of the fee, where are you going to negatively surprise a consumer? And you usually have a good feedback loop on that when you are getting complaints. And one thing, Paul, I'm curious to hear your view on, but I often hear from clients that they have a very generous refund policy. So what is the problem? If somebody complains, at that point, they will refund charges like a very big cancellation fee. It takes me back to kind of the wireless days with the early termination fees, that drove a lot of scrutiny in class actions. But how do you view subscriptions and really this whole user journey? Yes, they're regulated, but when do you strike it exactly right and clear and conspicuous disclosure?
Yeah, I mean, look, I was going to give some of these same examples because, Alysa and I have been working on these issues our entire career. In fact, I think I first met Alysa when I was on the enforcer side at the Texas AG's office, and we had an investigation. I'm going to say it, at least it was almost 25 years ago that we were working on these same issues. So that predates any of these state auto renewal laws. It predates ROSCA. It predates all of that. It was purely the basic UDAP theories that it is misleading and unfair to consumers unless you are being clear and conspicuous about the material terms, getting their consent, and then making cancellation easy, right? Giving them an out if they want to cancel. And so to your point, on the question about, liberal refund policies and does that address the concern, that may give you sort of a temporary reprieve, I guess, from enforcer attention, because enforcers are looking at the kinds of consumer complaints that come in. And so if they see that a company is being responsive and providing refunds, that may move you down on the list, I guess, of someone that they're going to focus on. But you're not going to be done with them, because if those complaints continue to come in, it's going to get on somebody's radar that gee, it's great that they're taking care of people that actually take the time to complain, but what about all the other people that haven't? Or worse yet, what about all the other people that don't know they're in this subscription still? And that's really the problem with subscriptions as a whole, is that from an enforcer standpoint, the most harmed consumers are never going to complain because they may not know that they're continuing to pay these amounts because for whatever reason, either the recurring charge isn't clear to them or it wasn't clear on the front end. So those are the kind of things that you just have to be very much aware of. But I go back to what I said before, is that, if you're looking at your practices and you can think about the story you're going to tell, right? If an enforcer comes and asks, think about what your user flow and user experience looks like, so that can you go and show an enforcer, here's how we disclose this information, here's how a consumer consents to it, and here's how easy it is for them to cancel. Those are those key questions that I think you want to be prepared and able to demonstrate. And just from a real practical standpoint, that's what's going to make you ultimately successful. This is an area that we're continuing to see a lot of enforcement in, as Alysa mentioned. Obviously, the case that we're demonstrating here is an FTC case, but states have been very active in this space as well. In particular, New York has brought a number of cases. They litigated against SiriusXM, a case that's still on appeal right now over certain issues. But something that was notable about that case, as you're thinking about your exposure in the subscription space, is that New York lost on claims under their state auto renewal law, but was successful asserting ROSCA claims because ROSCA has very broad requirements that require easy cancellation methods, that require clear disclosure of material terms. It's not as granular as some of the specific state laws that you may be able to find a hook and find a way to argue you're complying with. So again, I think the enforcement community is going to take a very, very broad look at your practices. They're going to look at consumer complaints and impact and potential harm on consumers. And those are the cases that they're going to prioritize.
And Paul, maybe just to put like a real fine point on this, how much a cancellation fee is, that's material.
Yep.
How do you cancel? And are those instructions clear, easily findable? I mean, I always go back to, if I just do an internet search, or now I do a ChatGPT search, am I going to find that really easy in connection with what you're offering? And if that is hard, or if it's confusing, or if you put everything within a very light gray link of terms and conditions and it's somewhere in a 26-page document, that's usually not going to cut it. So I think really focusing on, well, what's material? And how do I make that readily available to consumers, particularly for long subscriptions, right? Maybe that they went through the journey at the beginning of a year, you're going to charge them at the end of the year. Do they have reminders? Is it really easy? If they want to be able to cancel, how do they do so? Are there aggressive processes in place? You have to call them, or if you have to mail them via postal mail to cancel, and it has to get. So these are just all things to think about from a consumer journey. I do want to tie back one of the questions I think is an excellent one. I want to make sure that there's no confusion about it on surveillance pricing. Question being, companies have long used systems, CRM systems, and other kinds of data to model customers and determine, well, what are the kinds of offers, or what are the types of products that are going to be appealing? How do we do that? Does that now become a potential unlawful dynamic pricing? And I want to be clear that, of course, companies need to use aggregate data. You need to understand what your customers want, what kinds of offers are going to be appealing. And there is nothing wrong with that. There's a lot of discussion about the topic. I think the question and the real concern was using personal information to set an individual's price. The horror story of somebody has to go to a funeral and the airline price, was, I don't even know if that was real, but those are the kinds of stories that get let, that is very specific to taking advantage of a particular individual situation, as opposed to modeling prices for your customers and for groups of your customers.
Yeah, exactly. And I will note that I believe that airline has been very clear that they don't think that was real and that they dispute that. And again, I think it goes to some of the hypothetical concerns that may exist in the space, but still obviously an area people are paying attention to. So I think we can go to the next slide and move on to number 4, which is price gouging. And price gouging has always been a significant issue. And here we're talking about, basically speaking, charging excessive and high prices for essential goods and services. Typically, you find these laws triggered during a state of emergency or a natural disaster. You want to talk about a patchwork of state legislation, I would say price gouging laws are really the ones that you want to focus on, because there are so many differences state to state on what triggers price gouging laws, right? And I will tell you, as an ex-enforcer, when you're looking at the incoming consumer complaints, consumers think of price gouging just as high prices, right? But high prices alone doesn't trigger price gouging. You have to look at whatever the factors are in a particular state that do trigger a price gouging law. Some states, there are specific triggers for, there has to be a declared state of emergency. Some it's a state declared state of emergency. Some it's a state or a national emergency. There's variance about the duration of when price gouging laws are in effect. Some states it's during the duration. Some states it's the duration plus some additional window after the fact. Sometimes that additional window only applies to certain goods or services that relate to kind of the post-emergency type of services that you might need. So again, you just have to be aware of what the various state laws are. There's wide variance in the types of goods or services that are covered by price gouging laws. Some are limited to essential, that may or may not be defined as a term, but think basics like food, water, shelter, fuel. Those are pretty much a major focus area. But when essential isn't defined, you can get some maybe perhaps unexpected focus of states. So, for example, a few years ago, Texas, it was during I think it was post-COVID that Texas launched an investigation into the prices of ammunition, because they determined that was an essential good that they were looking into pricing related to potential price gouging accusations. So all of this is to say that this is a wildly varied topic, but it is one that, especially on the state enforcement side, becomes an emergency focus when you are faced with an emergency situation. So during COVID, during winter storms, during hurricanes, you're going to suddenly see resources at offices pivot and focus in on price gouging. And so especially if you are using some sort of automated system to determine your pricing that looks at demand and looks at extraneous factors that may not even be considering the specific nature of whatever emergency has arisen that is suddenly changing the landscape and changing the playing field for supply and demand, you need to be aware that these price gouging laws are in effect. So if you are just allowing those kind of automated price changes to happen and you're not being sensitive to the fact that a price gouging law may be in effect, you may find yourself running into potential violations, because one of the big areas of variance among the states is whether or not they define how much of an increase is actually price gouging. Some states give you specific percentage increases. Some states it's any price increase in the course of an emergency. Some states it's left open and ambiguous, and it's terms like excessive or exorbitant prices. So again, just understanding that backdrop and being sensitive to how your pricing structure is being utilized in the face of an emergency is very, very important. Last thing I'll say on this point too is just bear in mind too that emergency declarations in particular at the state level can go on for long periods of time. I mean, we've seen that in Texas where different emergencies have lasted for years. And so that whole window of time, price gouging laws are technically in effect. And so you just need to be aware of that and sensitive to that as you're setting prices.
So from price gouging, if we move to the next slide, we are going to go right into line item fees, which, Paul, this was another one of those topics that we met on the other side of the table a very long time ago. But the concept here is, company wants to advertise a price for a particular product, or maybe you've been buying this price for quite some time, but there is a separate fee that is on the invoice that sometimes has a name, sometimes it has an innocuous name, sometimes it has a specific name, but it is another fee. It's not a tax. And often it can be a type of charge that is the company is recouping, but it did not want to increase the price of the product. We see this quite a bit with some very creative names, and some of the issues in which you get in trouble are: one, is there a bait and switch? Is this illegal drip pricing? Can the consumer actually know what is the total price of the product or service that they're looking to buy, and certainly based on the advertising? And sometimes these line item fees, they're not necessarily de minimis, and they may fluctuate. And so how a company, is it gonna include a line item fee? What's the basis for the line item fee? Is it accurately describing the line item fee and disclosing it prior to purchase in the right way? If I'm a customer and I am searching on your site, where would I find more information about it? Is it in your service agreement or terms and conditions? We certainly saw this over the last few years in terms of tariff recovery fees or labor recovery fees. I mean, there was a whole lot of where companies were feeling a lot of pain from the current economic climate and trying ways to highlight the reason there is this added expense is pick your topic, and that's how they were choosing to recover it. It's an area where we see, in addition to regulatory attention, a whole lot of class actions as well. And so I think, like any fee that is going to affect the total price, you have to be really intentional and thoughtful about how you disclose it and how you charge it. Is it optional? Is it not optional? Can the consumer see the total fee for the product, the service, before they make the purchase? And think of that holistically. I would say the good news is that there's a ton of litigation and cases and enforcement examples that you can look to really pull out some best practices here, which are helpful to mitigate risk.
Yeah, I mean, I think at the end of the day, look, there's nothing wrong with a line item fee, right? As a general concept, right? I mean, I think this has been a historic practice, and like shipping charges are sort of the perfect example that especially enforcers understand and appreciate sort of that distinction. But I do think that you're right, Alysa. Like, there's so much litigation in this space too that there is risk, you assume, when you start to charge particular fees like recovery fees, and we're seeing that in the tariff space now, right? Once you open that door and you're specifically designating an amount and a line item charge for tariff recovery fees, when tariffs are held to be illegal, that can create litigation risk, right? And so again, it's part of the evaluation you should be thinking about on the front end as you're setting those particular fees.
Yeah, and we've
So,
seen even
oh,
fuel recovery fees. I'm just to
yep.
that point, and even in a B2B context, we've seen the FTC raise those kind of cases. So it's not just even necessarily to consumers.
And this is a perfect segue to our next item, because this, and actually the next two, I think, are all interrelated, and this is the pricing disclosures, right? So really, we see this a lot in the fee context, but is your description and disclosure about this particular price or a pricing claim accurate? And is it clear, or is it, potentially, misleading? And so, you've seen some enforcement around this. For example, the FTC and states have been looking at various online services and in the delivery space, and how they designate tips, and whether or not a tip is fully going to the individual driver, or whether or not the tip is used to offset other costs, or even costs related to some of those expenses for the driver. How you describe those charges becomes just a basic UDAP focus, right? And you're looking at whether or not statements about that price are false, deceptive, misleading, or unfair, right? And so I think that it's just something to keep in mind, that you need to be accurate and clear about what the price is for and what you are actually charging people, especially in the context of unbundling different charges.
That's exactly right. And then if we go to the next slide, which is the trifecta on these fee issues, is really the junk fees. And that was the rebranded but much stickier way of terminology for this. We have the FTC's junk fee rule, and that was very specific in terms of short-term lodging and live ticket events. But I think the UDAP concept is still, what is that all-in price? And A, can we see that all-in price? And where you have this other fee, are you being, when does the consumer first get to see it, but how are you describing it? So in the hotel space, of course, there was the resort fees, and some of those resort fees got to be $50, or there was, it was not a $1.50. So how you even describe the benefits, that's its own advertising issue of what are you actually getting with this fee, and the fact that is it mandatory or not, and then what is the consumer's, again, overall all-in price, so that they can make that decision on and make the apples to apples comparison, which was really one of the key drivers of regulatory attention here as well.
Yeah, and you're seeing a number of states now both considering and passing legislation that, in some instances just require all-in pricing and just require that you prominently feature the total price that includes all of these mandatory fees. Some are allowing a breakout where, as long as you are clearly disclosing in proximity to that price each of those fees, what they're for, that may be acceptable. But it's just, again, giving consumers the clear understanding of what they're going to pay is the most important piece here. I will say that, putting back on my old enforcer hat, the things that kind of get you in trouble and that people are focused on is where in the process are all of those fees being disclosed, right? If you are clearly disclosing all of the fees in proximity to a price, and you're doing it on the front end in initial marketing as consumers are approaching your site or your business, that's generally going to get less focus than if you're waiting until they're already going through the flow, the purchase flow, before you disclose a particular fee. Even if it's, clearly disclosed and described, you just want to be sure that in your initial marketing and what's driving consumers into that transaction is also being transparent about what those mandatory charges are. So that should take us to the next one, which are free trials. This is an interesting area because states have been looking at, obviously, states and the FTC have always been focused on the use of the word free and how that comes into any consumer transaction. But free trials really does come up a lot in the subscription space. And so as we've seen this rise in state auto renewal laws, you're seeing free trials becoming a key part of those laws. And I'm using the word free here, but really, we are talking about any sort of, front end discount, that may apply and then get automatically converted into something that's more expensive or that starts charging on a regular basis. Just like we talked about in the auto renewal space, I think the most important concepts when you're talking about a free trial are being just very clear to the consumer on the front end. Here's the duration of the free trial. Here's what's going to happen at the end of the free trial. Here's what you need to do in order to put a cancellation in process and ensure that you don't get charged if you don't want to be charged. If you are disclosing all of that and obtaining a consumer's acknowledgement that they understand those terms, that generally is going to help you be compliant with those various state auto renewal laws. But again, just from a UDAP standpoint, I mean, this really is an area that just at its core is just making sure consumers understand the transaction that they're entering into and what they're going to have to do to avoid those charges at a later date.
And Paul, you implied this, but I mean, we see this as invoice credits, and suddenly the credit stops. I mean, there's a lot of creative ways of what can be a free trial, in addition to some of the state and really locality laws that anytime you're using the word free, you have to have a certain disclosure of a certain size, a certain prominence.
Yep,
So you have that extra regulatory layer there to keep in mind.
that's right.
All right. So with that, we are going to move to number 9 in our top 10. So on material changes, you work with a business to come up with what is the price and how are we going to advertise it. But, particularly with subscriptions, where that price may need to go up at a certain point, or we talked about the discount ending at a certain point. You can even have the added layer of maybe you made claims on this is the forever price. This is the for your lifetime price. We have seen all of that. But at some point, changes in conditions, what have you, the cost of providing the product or service, the price has to change. And we get this question a lot on, well, do you need to provide notice? Can you just update the website? What and how specific do you have to be in that disclosure? And one, this pulls in a lot of the auto renewal laws that speak to material changes. So at the very least, you have to comply and address black letter law in these states, but we have also seen this certainly in many FTC cases just under normal unfair and deceptive trade practice laws, that you do have to provide advance notice and you need to do a risk assessment on whether you need another affirmative consent. So really things to think about. And we've seen kind of examples where this does not go well, the mass arbitration and class action on top of regulatory attention. So to be clear, this happens a lot. And it can happen a lot without any legal issues. It's certainly a normal thing that can occur, but there are the right ways to do it and risk mitigation ways to do it. And then there are the wrong ways to do it that drive a whole lot of legal attention. And that's really kind of the balancing to get it right.
Yeah, two things I'd add to this. One, in terms of the timing, Alysa, you're exactly right that auto renewal laws are increasingly addressing this and getting very granular about it too, right? That there may be very specific laws. New York is a great example that you must give either affirmative consent or allow people to cancel within at least 14 days after those changes occur. So there's like all of these windows of time that apply both on the front end to provide them with that notice and then giving consumers an out on the back end, if they're still dissatisfied with that change. And this is, although we're focused on price here, it really is any material change that impacts the consumer. And so that's kind of the other point I wanted to flag is that, AG Tong has mentioned this as part of his NAG initiative this year, but one of the areas that is price adjacent and related to this is the concept of shrinkflation, which has been around for a long time and discussed for a long time. But that's, generally this concept of changing packaging to like decrease the size, but make it look like a product that a consumer has traditionally bought. So if suddenly, I think the example that General Tong gave was peanut butter, right? If my jar of peanut butter now has this dimple in the bottom that has made it a smaller quantity than what I traditionally bought, but the packaging generally looks the same, the price is the same. That's a material difference to the consumer and something that I think the enforcer community is really taking a look at this year as part of this broader initiative to determine whether or not practices are being transparently communicated to a consumer. And so as you're thinking about those kinds of changes, it's just really important to be sensitive to the fact that consumers are going to complain as they identify those kinds of changes in what they've become accustomed to. And that's what's going to get on the radar of an enforcer.
Yeah, Paul, it reminds me, it really is that whole picture of what has changed. We've seen a lot of litigation on when an ingredient changes, right? So it looks a little bit different. And some of this is cost cutting to try to manage, the overall price. And we've seen when the key ingredient or the amount of that key ingredient changes. Is it a material ingredient? Is it a not material ingredient? Whether in beauty, in food products, how do you describe how the product has changed? And there's certainly discretion in some of those instances, but it can be material and you want to anticipate and mitigate those consumer complaints.
Yep.
So I think,
all right.
yeah,
This takes us to number 10. So final one to round out our list is promotional price related offers. And so this, in some ways ties back to what we talked about with free trials, but here we're talking more broadly about the types of promotional offers that a retailer may provide. And again, I think the importance here is clearly and effectively communicating to consumers what type of, either limited in time incentive or some type of promotion to the consumer is being offered and what that really means to them. And so a couple of real world examples to think about in this context. Late last year, a coalition of AGs announced a settlement with Menards about their rebate program. And here the issue was they were prominently promoting a rebate offering, but what the rebate really was earning amounts for store credit for future purchases. It wasn't actually money back or a discount off of the actual front end purchase. And so the AGs were focused on whether or not that was clearly communicated to consumers when they were at the time of their transaction, which they allege was not. Similarly, we saw the Washington AG filed a lawsuit against Albertsons earlier this month about buy one get one promotions, where the price of an item that is part of that buy one get one offer would be increased, and then the second one would be free. But the state's alleging that the price for in that transaction was actually never offered at an individual price. We've seen that in a lot of contexts. And again, it's just approaching this from what is the consumer friendly scenario here, right? I mean, consumers potentially are being misled about what the actual price of that item is in the context of a buy one, get one free offer, when all of the rest of the time it's offered individually at a lower price. That's something that needs to be clearly communicated to consumers, or maybe a practice that it's definitely going to get scrutiny of enforcers.
Yeah, and I would just add, particularly for like buy one, get one free BOGO offers, we've got long-standing FTC material guidance on that. I would also say I'd put in this top 10 up to claims, right? Savings claims. There is a lot of body of law on those. And what is the standard for your substantiation to make sure that you don't, face the risk of a bait and switch type discount savings offer?
Yeah, and just more broadly, right, in that kind of savings claims, reference pricing area, right, you've got FTC guidance and you have a number of state laws and regulations too that apply, right? And so just making sure you're aware of how long do you really need to be offering an item at a particular price before you can offer a promotion that purports to provide savings. That's all under state and federal scrutiny, and you just need to have a full context of what that regulation looks like.
So I think if we go to this last slide, it's just our top 10. And I think as you're working with the business, it's always helpful to keep everybody apprised. You've got a lot of new folks sometimes coming in and out. And while not all of these are new, shiny laws, but I think the 101 bread and butter concept of price sensitivity and advertising relating to price and using data in connection with those prices, starting with the fundamentals, goes really far in helping mitigate overall risk. So with that, just really appreciate folks joining. We are going to continue the series. We are going to have another blog post out. We've got already some posts now on surveillance pricing. If you do a search on the blog, thoughtaccess.com, we've got it in the comments. But thanks everyone for joining, and we really look forward to seeing you for our next in the series, which, Paul, I think we're doing sometime later June. Date will be.
That's right. Yes. Date is TBD. It will be in later June, and we will be doing more of a deep dive into surveillance pricing, which I circling back to the beginning, I do think is probably the hottest topic in this space right now, and one that everyone should be paying attention to.
All right. Thanks, everyone.
Thank you all.